Please, we will start our plenary session, and may I now request the chairman of the plenary session, Justice N. Koteshwar Singh, to please come on the dais. May I also request Justice V. Ramasubramaniam, His Excellency Dr. Kamalini Pinit Puvadol, Mr. Andre Hogg, may I request all to please be seated. The Honorable Mr. Justice N. Koteshwar Singh, Mr. Justice V. Ramasubramaniam, other dignitaries on the dais and off the dais. A good morning and welcome to all. It is a privilege and honor to be with you today at the second New Delhi International Rule of Law Convention and to co-chair this plenary session on global economic governance and principles of the rule of law. At the outset, I extend my gratitude to Bar Association of India for convening such a meaningful platform that brings together jurists, policymakers, scholars, and practitioners from across jurisdictions. We have a galaxy of speakers today to deliver keynote addresses on various topics, and I don't propose to touch upon each subject. However, I would make certain general observations. Rule of law in India go long back. We have heard our distinguished speakers in the morning session dwelling on the past history of India and how rule of law has been part of it. From ancient times, the rulers ruled the country with laws, and traditionally it continued. One remembers the great Judge Ram Shastri 400 years ago, who punished King Raghova Peshwa. Even today, our judiciary keeps in check faltering executive. The rule of law is not merely a legal doctrine. It is a bedrock upon which sustainable economic governance is built. A transparent, predictable, and impartial legal system ensures investor confidence, promotes fair competition, and enables inclusive growth. Without it, markets falter, corruption thrives, and inequality deepens. Globalization has created interdependencies that make economic governance no longer a purely domestic affair. Cross-border trade, investment flows, digital commerce, and financial markets demand rules that are consistent, enforceable, and rooted in universally accepted legal principles. However, economic governance cannot be discussed in isolation. One of the gravest threats to the global order today is cross-border terrorism. Terrorism not only violates human rights and security, but also disrupts economics, diverts resources from development, and undermines trust between nations. Terror networks exploit weaknesses in financial systems, money laundering, illicit trade, digital frauds, and unregulated digital currencies to finance their activities. Therefore, a global economic governance framework must integrate robust mechanisms to counter terror financing, enforce accountability, and foster economic cooperation. The way forward lies in, firstly, in strengthening international legal instruments, global conventions on trade, investments, and anti terror financing must be implemented with sincerity and backed by enforcement mechanisms. Secondly, in judicial and institutional cooperation, courts, regulators, and enforcement agencies across borders must collaborate to address disputes, fraud, and financing of terrorism. Thirdly, in balancing sovereignty with collective responsibility, while states retain their sovereign right to regulate economies, they also share a collective duty to uphold principles of fairness, transparency, and accountability in the global commerce. Fourthly, in harnessing technology responsibly, digital trade, artificial intelligence, and fintech innovations bring opportunities but also vulnerabilities. A rules-based order must evolve to regulate these frontiers without stifling growth. In conclusion, as a members of the legal fraternity, it is our responsibility to reaffirm the principles that law must serve as a shield for the weak, a framework for the economy, and a barrier against terror. This convention is not just an academic exercise, it is a call to action to shape a global governance system that is just, equitable, and resilient. Let us work together to ensure that the rule of law remains the guiding light for economic stability and peace, even in the face of the grave challenges of cross-border terrorism. Thank you. I now give the floor to the chairman, who is a judge of Supreme Court. I would like to introduce that His Lordship has been judge of Guwahati High Court from 2011, and he was appointed as a judge of the Manipur High Court with effect from 23rd March 2013. He has been working as a judge of the Supreme Court of India from July 2024. His Lordship has participated in the World Congress on Justice for Children at UNESCO Paris, and he was part of the 8-member High Court judges team to attend workshop on counter-terrorism phase 2 training at Washington DC and Orange County, California. He has also participated in the International Organization for Judicial Training Conference held in Ottawa, Canada, and he took part in the South Asia Regional Judicial Dialogue on the Bangkok General Guidance for Judges on applying a general perspective in South Asia. May I now request all of you to put your hands together for Justice N. Koteshwar Singh.
Now today's this plenary session, which is supposed to start at 11:15, our train is late by about 45 minutes. So, without much ado, we'll go straight to the master storyteller, Justice V. Ramasubramaniam. He's one of the wonderful, the most, I think, erudite scholar in Sanskrit, in Indian traditions, and also, of course, a master of law also. So we'll eagerly awaiting to give your views on rule of law and Indian tradition. Of course, I snatched a few, I think, of your domain in my speech in the morning. I mentioned about dharma and Raj Dharma. Of course, he is going to go much more beyond that and much more in depth. So I will request Justice V. Ramasubramanian, who is also the chairperson of the National Human Rights Commission in India, after his demission of office from the Supreme Court of India. I request Honorable Justice. And of course, because time is a constant, I would request the speaker. There are 5 speakers online, so about 10 minutes or something like that, that perhaps would do justice, or we'll see that subject, of course. Just a suggestion, not a mandate, of course. Thank you.
My good friend, Justice Koteshwar Singh, distinguished panelists on the dais, very distinguished invitees. Justice Koteshwar Singh indicated that it is only a suggestion that we stick to the time. But since I am out of the system and you are part of the system, I don't want to be hauled up for contempt, because no one knows what happens in the Supreme Court these days. No, I am saying something in the positive. I don't know why you are all clapping. See, people always misunderstand me whenever I say something positively. It is good that, in fact, in a way, it is good that we start this session 45 minutes later, because today I think the Rahu Kalam was between 10:30 and 12 o'clock. And whenever we start a rule of law conference, rule of law, a symposium or a conference behind schedule, it is a message that we send to people that how important time, which is also part of the rule of law. So you can establish certain things in the positive, certain things in the negative, and this is one way of doing it. I do not know. I think the other speakers are going to speak on various topics which are contemporary in point of time. I do not know how the topic assigned to me will fit into the scheme of things. I am supposed to talk on rule of law in the Indian tradition. I don't know. Let me try to fix it here. The Rig Veda, which is the first gateway to knowledge in the whole universe. No, let him complete it.
Can you please cut short your call and switch off your phones or put it on silent?
No, maybe that's a very important call.
Please.
The Rig Veda declares in Mandala 1, hymn 25, Yachiddite Vishoyata Pradevam Varunavratam Minimasi Dyavidyavi. The meaning of this Rig Vedic verse is, O God, Varuna, as we are human beings, day after day, we violate whatever laws of thine, but give us not as a prey to death. Look at the beauty of this Rig Vedic sentence. O God Varuna, as we are human beings, day after day we violate whatever law of thine. That means the earliest gateway to knowledge acknowledged 2 things. Number 1, that we are governed by laws. Number 2, that we as human beings are prone to violate the laws. So violation of law, violation of the rule of law is not something new. It is recognized even in the Rig Vedic times. That probably is the context in which this topic has been assigned to me. What we understand by rule of law in contemporary times, and how was it in the ancient Indian tradition is what I would focus in the next 4 to 5 minutes before I wind up. A.V. Dicey, the eminent British jurist, he identified a rule of law by 3 factors. Number 1, absence of arbitrary power. Number 2, equality before law. And number 3, predominance of legal spirit. These are the 3 factors with which he identified rule of law. But the United Nations organization identified 9 factors. These 9 factors are supremacy of law, equality before law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. These are the 9 factors which United Nations organization advocated as factors that constitute the components of the rule of law. All of you must have heard about this World Justice Project, WJP, which actually prepares a rule of law index. I have a lot of problems with that rule of law index. Anyway, I will not talk about it today. We will reserve it for another session. This WJP rule of law index is based upon 8 factors. What are those factors? Constraints on government powers. Number 2, absence of corruption. Number 3, open government. Number 4, fundamental rights. Number 5, order and security. Number 6, regulatory enforcement. Number 7, civil justice. And number 8, criminal justice. Apart from these 8 major factors, there are also 44 sub-factors which are taken into consideration before a country is ranked in the rule of law index. In the year 2024, the country of Denmark was ranked number 1 in the index. It continues to be ranked for the past few years in number 1. And Venezuela happens to be at the bottom of the list of 142 countries. In fact, when I opened this rule of law index, I straight went to 142 because I did not want my country's name to be found there. I heaved a sigh of relief. It was Venezuela, not our country. India is placed along with Tunisia, Guyana, Thailand, Brazil and Vietnam, all of which are assigned a score of 0.50 out of 1. Hong Kong is placed at 23 with a score of 0.72 out of 1. I am just giving you the fact without drawing any conclusion, inference or adverse inference. What is interesting about this ranking is that while placement of a country at a particular rank in the overall index may be at a particular level, the placement of the same country in the index in respect of each of these factors may vary. For instance, one of the Southeast Asian countries, insofar as freedom of press index is concerned, it is at the bottom, because if anyone criticizes the king or the government, he will be imprisoned. But when they take all these 8 factors cumulatively into account, the ranking of this country goes high above India's. So there are issues as to how we assimilate these factors. Now, having taken note of this contemporary view of the rule of law, let me just come back to where we began about this Indian tradition. All of you know that we have, in every country, we have a system of hierarchy of laws. You may call it Kelsen's hierarchy or whatever. Take our own country, Constitution is the founding document out of which all laws emerge. So that is the primary source. From out of the constitution you have the laws enacted by the parliament and the state legislatures, acts of parliament, acts of legislatures, this is the second source. The third source are the rules framed under the respective laws, and the fourth source of law are the judgments of the court, constitutional courts. If the hierarchy of laws in contemporary times has got four sources of law, even in the Vedic times, we had four sources of law in India. That's quite interesting. Manu, who later became very controversial for some of his statements, he declares what are these four sources of law in a very beautiful verse. He says, Vedo kilo dharma moolam, smriti silecha tadvitam, acharas chaiva sadhunam, atmanas tushtirevacha. What are these four sources? Vedo kilo dharma moolam. The first source of law in Indian tradition is the Vedas. Vedo kilo dharma moolam. The second source is smriti silecha tadvitam. Smritis, what are called dharma shastras, they constitute the second body of law, second source of laws. Then the third is very interesting. If something is not found in the Vedas, if something is not found in the Smritis, Dharma Shastras, then what is the third source of law? Acharas Shaiva Sadhunam, the conduct of learned and noble men. The phrase is very carefully articulated. It is not the conduct of learned men, it is the conduct of learned and noble men. Otherwise, I think all we lawyers, we call each other learned members of the bar. And is it worth emulating our conduct? Can it constitute the rule of law? Certainly not. I think all of you are in agreement with me. I am very happy. So, acharas shaiva sadhunam, the conduct of learned and noble men. This is the third source of law. The fourth source of law, to my limited knowledge, cannot be found in any jurisdiction in the world. Acharas chaiva sadhunam atmanas tushtirevacha. The fourth source of knowledge is one's own conscience. If you do not find what is right and what is wrong in the Vedas, if you do not find it in the Dharma Shastras, if you do not find it in the conduct of learned and noble men, ask your conscience. It will tell you what the law is. This is how four sources of law were articulated by Manu. All of us celebrate this statement, be you ever so high, the law is above you. We often repeat it. This statement, many people attribute it to the great English jurist, but actually that statement is found in a document of the year 1732 by Dr. Thomas Fuller, who was a British physician, not a lawyer. This aphorism, be you ever so high, the law is above you, is not by a lawyer, not by a jurist. It was a book written by him titled Nomologia, Adages and Proverbs, Wise Sentences and Witty Saying, Ancient and Modern, Foreign and British. That is the title of the collection. It's a proverb which finds a place in the collection of proverbs authored by a British physician in the year 1732. Be you ever so high, the law is above you. But as he rightly said, he only collected from the ancient sayings. He did not create this aphorism by himself from out of thin air. If you look at our tradition, this is found in the Itihasas and the Puranas of this country repeatedly. In the Ramayana, There is a very interesting statement by Lord Rama. He tells Ravana one sentence. He says, "Be you, Brahma, the creator of this universe, but you are bound to perish if the rule of law perishes." Rama places Brahma, the creator, below the rule of law. Not even the king. The Western tradition placed the king below the rule of law. Rama placed the creator below the rule of law. In the Shanti Parva of the Mahabharata, there is a very interesting statement by Yudhishthira. He says, the proper function of the king is the maintenance of law, not the enjoyment of the luxuries of life. He also reiterates, law is supreme, so the king who regulates society in fulfillment of the law discharges his functions appropriately. In verse 9, chapter 5 of Ashramavasika Parva of the Mahabharata, Dhritarashtra tells Yudhishthira, that is, I think, the final statement with which I will conclude. Dhritarashtra tells Yudhishthira, the state can be preserved only under the rule of law. I think that constitutes the rule of law in the Indian tradition. Thank you very much.
Thank you, sir, for the wonderful dive into the past with so much of clarity, which we do not find any difficulty in understanding in the present context. We then, of course, go to the next the cross border. No, okay. Now we go to, because I'm told that the second topic was supposed to be addressed virtually. Okay. Okay, so we'll await his connection. In the meantime, we'll proceed with the third topic on Asia-Africa legal cooperation role of ALCO. It's a very important Asia and Africa. We are so distant. It appears to be so distant, but our historical evidence shows that India was well connected with Africa during even the Roman times. There is the evidence to show that ships used to go from India to the other shore of African shore. But let us reconnect it to rebuild a new world order. I welcome respected speaker, Dr. Kamalin Pinipu Vadol, Secretary General of ALCO, to give his speech to enlighten us on this very important aspect. Thank you very much.
Yes, it is my great pleasure and honor to be represent the ALCO, the Asian African Legal Consultative Organization, at this very important event, and I'd like to convey my heartfelt appreciation to the Bar Association of India for inviting ALCO to be part of this event and for convening this such a timely platform to reflect on the rule of law in building a fairer and more inclusive legal orders. It's not the record, not the first time that ALCO joined this very important event with the Bar Association of India. Since ALCO is not the new organization, we set up in 1956, and in my record, our first Secretary of ALCO, Mr. B. Sen, or Barry Sen, he served and worked with the Bar Association of India, and also he used to be the senior advocate at the Supreme Court of India also. So, and I'd like also to convey my heartfelt thanks to the President, Mr. Prashan Kumar, for inviting ALCO to be part of these very important events. My topic is the role of ALCO. Perhaps some of you may wonder what is ALCO. ALCO is the Asian African Legal Consultative Organization. Even ALCO is not part of the UN's network system, but ALCO is quite a long history. We are the intergovernmental organization set up in 1956 as we can say the tangible outcome of the Bandung Conference. Some of you may heard about the Bandung Conference in 1955 held in Indonesia that time. And if we back to the 1950s, the time after the Second World War, the process of decolonization, member countries can say from the South join at the Bandung to think about their future in many issue economic developments. And one of the issues is on how the countries of the Global South, Asia, Africa can contribute to the process of developments and the codification of international law. That's why ALCO is set up. And since 1956, that time we set up as the committee to provide the platform for the legal advisor of the countries in Asia and Africa. And also we provide some study and to help the countries to engage more in the universal platform. For example, at UN platform, when the countries join at the discussion on many particular topics of international law. And I can say that at the beginning we have the only 7 member states, and India is also one of the founding member states of ALCO. And now we have 49 member states from Asia and Africa. We have 32 from Asia, I think covering all the countries, even from the South Asia, East Asia, Southeast Asia, and 17 from Africa. And from the very beginning, ALCO mission has focused mostly on the promotion cooperation between Asia and Africa in the development of international law. And second, on the upholding the rule of law, as we discussed today, the rule of law in international relations in close cooperation with the United Nations. So my presentation will be brief. We will highlight some focus outcome of the ALCO during the can say the 49. We will celebrate next year 70 years of the setting up of the ALCO. The promoting cooperation in development of international law. As all of you may know that international law does not develop by simply accepting rules made by elsewhere. For us, from Asia and Africa, it's been taking part in shaping those rules so they reflect our realities, values, and aspirations. And ALCO provides the forum where this collective voice is heard. For example, may I allow me to highlight some of our flagships contribution to the international law in the platform of the UNs. For example, the law of the sea. Before the adoption of the UNCLOS, some of you may know about the UNCLOS, the United Nations Convention on the Law of the Sea in 1982. ALCO was already debating ideas such as the EEZ, the Exclusive Economic Zone, and the common heritage of mankind. This discussion helped ensure that the priority of the Global South of the developing coastal and landlocked states were reflected in the United Nations Convention on the Law of the Sea. The topic of state responsibility, as some of you may know, and combined with the diplomatic protection, ALCO enabled member states to exchange views on key principles such as wrongful acts, repatriation, and the nationality of claims, issue that remains vital for protecting the rights of states and their nationals. The succession of states for newly independent states, ALCO deliberation on treaties, properties, and debts of direct importance and contribute to shaping the Vienna Convention of 1978 and 1983. And on the issue of joint investment, very important. Since the beginning, some of you may know that during the years 1960, even 1950, 60, they have discussion at the UNGA on the issue of the state sovereignty over natural resources or the new international economic orders. And I'll go be part of this discussion during the 1958, 60, and even 70. And also, ALCO contributes to many creation, for example, the creation of the MIGA, the Multilateral Investment Guarantee Agency, at that time in 1980. And in our recent work, we are focusing on the issue of the reforming the ISDS, the Investor State Dispute Settlement. We work together closely with the UNCITRAL, the United Nations Commission on International Law, Working Group 3, which focus on the ISDS reform. And ALCO has ensured that the investment rules reflect concerns of our countries from the Global South, Asia, and Africa. And there's many emerging issues that we worked today. ALCO discuss many current topics as the cyber law, cyber crimes, the AI, the climate change, and even space law. It has also launched the expert forum on asset recovery to support member states in tackling corruption and illicit financial flow. And this initiative helped to ensure that Asia and Africa are not left behind in the future evolution of international law. And on the issue of how upholding the rule of law in international forum or international relations. For Asia and Africa, the rule of law means that international relations must be governed not by power, but by fair rules, applied equally to all states. ALCO works closely with the United Nations to make this principle real. With the International Law Commission, or ILC, ALCO provides a platform for member states to discuss complex topics such as immunity of state officials, helping balance sovereignty and accountability. On the ICC, International Criminal Court, ALCO serves as a neutral platform for dialogue among states with reference position on the Rome Statutes. And with the UNCITRAL, ALCO has supported the development of a fairer commercial and arbitration rules, including the ISDS reform, as I mentioned earlier. And in today, we work on another many silent topics, such as the issue of environment challenge. ALCO has followed the works of the ILC and also follow the, as some of you may have heard about the ICJ advisory opinion on climate change and the state's responsibility. This debate reaffirmed that the rule of law must guide global response to such urgent challenge. And as we look forward, as I mentioned that ALCO will celebrate the 70 years next year in 2026. We are preparing for the futures, and our vision focus on at least 3 pillars issues. Deepening Asian-Africa legal solidarity. This is very important. We like to encourage participation from the countries Asia and Africa in the process of development and codification of international law. And advancing the development of international law within the UN and authors partners, like the author, the IO International Organization. And also we provide a kind of practical tools to help member states as a special study, model law, even the model treaties on investment issue also. And let me also acknowledge the pivotal roles of India, a founding member state of ALCO. The permanent host of ALCO's headquarters is in New Delhi in Chanakyapuri. India has always been at the forefront of shaping ALCO's agenda and continue to support its work. And hosting this conference once again reflects India's strong commitment to the rule of law, to the global legal cooperation. So in my conclusion, I'd like again to convey my heartfelt thanks to the Bar Association of India for organizing this event and inviting ALCO to be part of this important events. And the rule of law is very important. This morning I listened to many speakers. I'm impressed by many speeches, and one that I like to raise again by Excellency's Honorable Mr. Justice Singh, when he mentioned that the rule of law, we cannot claim, without the rule of law, we cannot claim diplomacy, we cannot claim prosperity even anything, because the rule of law is the foundation of everything. And I think that the rule of law is the rule, not the rule of lawyer, but the rule of everybody. But we need to engage many more people to understand and respect the rule of law. So thank you very much for your kind attention.
Thank you, Dr. Kamalini, for the wonderful insight into the contemporary situation about rule of law, which connects all the continents. And Dr. Kamalini, if I venture to say a few words about your name, Kamalini, it I think is derived from the word Kamal, the lotus. Yes, Sanskrit. The lotus actually indicates purity, because it is so because if you plucked lotus from water, the water does not cling to it. It indicates the purity. That's why lotus is one of the favored flower for offering to the gods. And we have also revived that kind of historical ties we had. Rajendra, during the Rajendra Chola, Rajendra, the king, Chola I, who incidentally hails from the place where Justice Ram Subramaniam also hails. During, that is 1,000 years before, we had this connection, interaction with the Southeast Asian countries, where both Buddhism as well as Hinduism had a presence, and not through any act of war or force was used. It was just a kind of very peaceful kind of interactions. So we had these historical ties which have been again revived, and I'm sure with this historical bonding already in existence, the new attempt to force fresh ties will not be a difficult one. Thank you very much, Dr. Kamalini, on this. Now we are waiting our learned advocate, Attorney General of India, who is going to address us virtually. He is presently located in Kerala to attend a very important function there. The learned Attorney General is again himself a scholarly person, and he has intimate knowledge about the state of affairs, and we shall see, certainly his talk will help us navigate the delicate balance. How? Okay, I'm told that there is 10 minutes. Okay, fine, no problem, we'll wait. Then we'll go to the next topic of discussion on Council of Europe's Convention on the Protection of Lawyers. Is very important, though we are not members, officially members of the committee, I understand, but our connection again with Europe is also quite deep-rooted. Many of us, the modern education in India is based on the Western education at least, and we could imbibe many of those thoughts which were the product of the European Renaissance, which has great influence in our national movement also. Yes, of course, the whole concept of the justice, equality, liberty, though we may think that we may have borrowed from the French Revolution, which was the very, but I think that the whole concept was already there in Indian subcontinent, the whole concept of liberty, equality. I just reminded of this very famous speech by Swami Vivekananda in Chicago, where he mentioned about when the Israelites, when they were overwhelmed by the Roman Empire, they came to the Western India, and they were welcomed by India. They were not asked to convert to Indians. They were allowed to continue the tradition, similar with Zoroastrians when they were overrun by in Iran. They also came here. So we have, and we had this whole tradition of welcoming, treating them as equal partners in this universe, our existence, and that also shows the fraternity, the equality, and the justice. So, but then it connects with the views of the Europe, and I will request Mr. Andre Hoog, the Vice President of German Federal Bar, to address us on this very important aspect. Thank you very much.
Thank you very much, Honorable Mr. Justice Singh, for this friendly introduction. Excellencies, distinguished guests and colleagues, first of all, congratulations to the Bar Association of India for putting together this excellent Rule of Law conference. It is my first
visit to India, and after my first day, I'm already very impressed by the deep-rooted culture of this beautiful country, and I feel very honored to be invited to give a keynote speech at today's event. Please allow me to shortly introduce the German Federal Bar and myself. My name is André Haug. I am a practicing lawyer and since 2018 Vice President of the German Federal Bar. The German Federal Bar, or in short BRAC, is the umbrella organization of the legal profession in Germany. Our members are the 28 regional bars, which form the regulatory body of the legal profession in Germany. The German Federal Bar has represented the interests of lawyers at a national, European, and international level for over 60 years. With the expertise, competence, and experience of lawyers from a wide range of organizational forms and practice areas, the BRAC advocates for the protection of the rule of law, the strengthening of independent lawyer self-governance, and the protection of lawyers' core values, in particular vis-à-vis Parliament and the ministries. The BRAC is not only active nationally, but also internationally. The German legal profession also plays a key role on the international stage in helping to shape legal cooperation and intercultural dialogue in the field of law. The aim of our international work is, among other things, to contribute to the establishment and maintenance of rule of law structures, to introduce and strengthen an independent and self-governing legal profession, and to engage in exchange on different legal concepts for the joint further development of the law. International events, such as this one in particular, offer the opportunity for exchange and in-depth discussions. The theme of this year's Rule of Law Convention is Global Economic Governance and Principles of the Rule of Law, with a particular focus on economic governance and cross-border terrorism, a topic that is particularly relevant for India in the light of the event of April 22, 2025. 26 tourists were killed in a terrorist attack in the Indian part of Kashmir. The victims were mostly Indian holiday makers. From the point of view of the terrorists, they were following the wrong faith. According to media reports, the militant group, the Resistance Front, has claimed responsibility for the attack. The incident has further aggravated tensions and again fueled the long-running conflict between India and Pakistan. It is not only here in India that terrorism repeatedly triggers fear, social destabilization, and has an effect on economic growth, tourism, and investment. Since the terror attack in October 2023, we have been able to witness the ever-widening crisis in the Middle East until today. We, the international lawyers community and representatives of national as well as international lawyers organizations, will address these and other topics in depth over the next 2 days in the event. First of all, however, I would like to draw your attention to another important rule of law topic that is currently preoccupying the legal community in Europe, and this is the Council of Europe Convention on the Protection of the Profession of Lawyer. The Council of Europe is an international organization founded in 1949 to promote and uphold human rights, democracy, and the rule of law. It has 46 member states and developed within this framework numerous multilateral agreements called conventions. This year, the Council of Europe adopted the first ever binding international agreement aiming to protect the profession of lawyer. This is notably to respond to increasing reports of attacks on the practice of the profession, whether in the form of harassment, threats or attacks, or interference with the exercise of professional duties, by way of, for example, obstacles to access for clients. To achieve this, the new Council of Europe Convention on the Protection of the Profession of Lawyers aims at setting minimum standards to states that exceed the Convention are not hindered from introducing higher protection for lawyers. It also takes into account the differences between the organization of the legal profession in various countries. These attacks we are seeing are not only carried out by angry, criminal, or extremist individuals or groups, but are often fueled by media that associate lawyers with the actions of their clients, thereby exposing them to life-threatening attacks. In various countries, lawyers and their organizations are also attacked by the state. These attacks do not only occur in Europe. The latest executive orders issued by the president of the world's largest democracy and most powerful nation are just one example. These orders suspended security clearances held by lawyers, restricted their access to government buildings, required government contractors to disclose whether they do business with a particular law firm, and called on agencies to take steps to terminate contracts with law firms of their clients. Even the American Bar Association is currently under pressure. Its funding for legal training has been cut, and government lawyers have been instructed not to participate in ABA events. In Turkey, the legal profession is also under attack. Just recently, a Turkish court arbitrarily dismissed the entire board of the Istanbul Bar Association, including its president. At the same time, the members of the Bar Association's board are facing criminal proceedings and long prison sentences. The background of these events is just a press release by the Istanbul Bar Association calling for an investigation into the killing of 2 Kurdish journalists by a Turkish drone airstrike. Only in July, Law Asia issued a statement on the harassment of lawyers from Azerbaijan and Russia regarding reports citing unlawful detention, the arrests of journalists, the harassment of lawyers, and the denial of legal representation. Law Asia has emphasized the need to adhere to the rule of law and called for the exercise of restraint by the relevant authorities. As we all can witness, lawyers in various jurisdictions have long been and are increasingly being intimidated, preventing from doing their work, or even physically attacked for representing unpopular clients. Lawyers play a key role in upholding the rule of law and in securing access to justice for all, which includes the vindication of possible human rights violations. Therefore, public confidence in justice systems also depends on the role played by lawyers. The Council of Europe Convention on the Protection of the Profession of Lawyers aims to protect lawyers and their professional association, whose role is vital in defending lawyers' rights and interests as a profession. I would like to quickly walk you through the convention and briefly summarize its provisions. With its 24 articles and 5 chapters, it is pretty straightforward. As already mentioned, the purpose is to strengthen the protection of the profession and the right to practice without fear of discrimination, improper hindrance or interference, or of being subject to attacks, threats, harassment, or intimidation. The scope of application covers professional activities of lawyers and their employees, as well as people who want to become lawyers, and also, last but not least, professional associations of lawyers. Article 4 is important for us bar associations. It deals with the responsibilities and role of the professional association of lawyers in safeguarding the profession's principles and standards and in protecting the individual members of the legal profession, particularly in situations where they are not able to defend themselves. Article 5 concerns the standards for entry into the profession, continued authorization or readmission of lawyers to practice. Article 6 obliges the states party to the convention to ensure that lawyers are able to exercise rights that are fundamental for the exercise of the profession of lawyer. Article 7 obliges the states party to the convention to ensure that lawyers and their professional associations can express themselves not only on matters connected with the practice of the profession of lawyer, but also on matters concerning the law and its application in general, including aspects related to the protection and promotion of human rights and the need for reform. Article 8 deals with disciplinary proceedings against lawyers, and Article 9 obliges states to ensure that certain measures are adopted and that they refrain from certain actions so that lawyers are protected in a number of specific situations where they are particularly vulnerable to abuse. It also obliges them to ensure that lawyers and their professional associations are protected from being attacked, threatened, harassed or intimidated or otherwise being hindered or interfered with when carrying out their professional activities. As you can see, ladies and gentlemen, the Convention's substantive provision set high standards for the protection of the legal profession and its associations. When you look at the Convention in detail, you will see that a number of rights have been formulated in a very differentiated manner. For example, Article 9 states that a lawyer deprived of their liberty shall have access to a lawyer of their choice, be able to inform their professional association, and be entitled to have a representative of their professional association or a lawyer present during any search, the seizure of documents and data. This provision, for example, further strengthens the lawyer-client confidentiality, a core value of the legal profession. In order to guarantee this right, the signatory states undertake to amend their procedural rules to protect the legal profession. Article 9 also strengthens the rights of professional associations as safeguards of individual lawyers, especially the right of access to lawyers who are deprived of their liberty and the possibility of attending hearings in any proceedings brought against lawyers on account of their professional activities are strong mechanisms to be able to limit state arbitrariness. The Convention also states specific obligations of signatory states. According to Article 9, for example, states must ensure that lawyers can carry out their professional duties without being the target of any form of physical attack, threat, harassment, or intimidation, or any improper hindrance or interference. Where such circumstances could amount to a criminal offense, the state must also ensure effective investigation. Furthermore, they must also ensure that professional associations can operate as independent, self-governing bodies. As you can see, these binding substantive provisions of the Convention are a major step toward better protection of lawyers and for their professional organizations. Like other international treaties, the Convention also provides for a monitoring mechanism in Chapter 3. The centerpiece of the monitoring mechanism is a group of experts called GRAVO. GR is for group and AVO for avocat, which is the French word for lawyer. The GRAVO is a body established by the Council of Europe to monitor the implementation of the Convention on the Protection of Lawyers. It is composed of 8 to 12 independent experts who evaluate how signatory states are upholding the Convention's principles, including the protection of lawyers from attacks and ensuring their professional independence. Its primary role is to monitor how states that have ratified the Convention are implementing its provisions. GRAVO is supposed to use targeted questionnaires to gather information on the Convention's implementation from state authorities. When necessary, GRAVO can arrange in-country visits to collect information and assess the situation firsthand. The expert group will prepare reports with conclusions for each state based on the information gathered. They can initiate urgent procedures for serious violations of the Convention. GRAVO also provides guidance on themes and concepts related to the Convention and can issue recommendations to the signatory states. Another pillar of the monitoring system is a political body called Committee of the Parties, as set out in Articles 11 and 12 of the Convention. The Committee of the Parties comprises representatives from each party to the Convention. It is responsible for electing the members of GRAVO, the expert monitoring group I've just mentioned. Beyond its electoral function, the Committee of the Parties promotes cooperation and dialogue among states, follows up on GRAVO's conclusions, and may adopt recommendations to support compliance with the Convention. Although it does not alter GRAVO's findings, the committee introduces a political dimension to the oversight process, thereby strengthening accountability and fostering shared responsibility among states in safeguarding the independence and safety of lawyers. This was a short summary of the monitoring mechanism. Let me turn to the final chapter 5 and the question of how to become a party of the Convention. The Council of Europe's Convention on the Protection of the Profession of Lawyer was opened for signature on May 13, 2025, and was signed by 17 countries on the first 2 days. These included Andorra, Estonia, France, Greece, Ireland, Italy, Lithuania, Luxembourg, the Netherlands, North Macedonia, Norway, Poland, Sweden, Belgium, Iceland, the Republic of Moldova, and the United Kingdom. On July 4, 2025, Bulgaria signed the convention as 18th country. Germany is not part of the convention as yet, but we are hoping that it will only be a matter of time until we sign. The convention is in principle open for accession by all states worldwide, and also the European Union can accede. All member states of the Council of Europe and those states that took already part in the elaboration of the convention, that is, for example, only Mexico, can sign and ratify the convention already now. Any other state can do so after the convention entered into force, and only after being invited by the Committee of Ministers of the Council of Europe. For the convention to enter into force, it must be ratified by at least 8 states, 6 of which must be Council of Europe member states. As of mid-July 2025, none of the signatory countries has yet completed the ratification process. Thus, the convention has not yet entered into force. First estimations expect this to happen around the end of 2026. So much for my short introduction to the Council of Europe Convention on the Protection of the Profession of Lawyer. Maybe as a final remark, the convention is very important to Prague. We, and in particular the colleagues from our Brussels office, have been involved since the first early discussions on the convention in 2015-2016, and have been particularly active in the development of the content and wording from 2022 till 2025. The Council of Europe working group that drafted the convention was chaired by the German expert Dr. Christoph Henrichs. As you can see, we made a major contribution to its creation, so the convention is partly, as they say, our baby. That's why we have an increased interest in raising awareness, even though Germany has not yet signed the convention. According to a spokesperson of our Ministry of Justice, the ministry is working intensively on speeding up the signing process. I hope I was able to raise your interest in the convention, and thank you very much for your attention.
Thank you, Mr. Andre Hong, for a wonderful exposition on the very important area of collaboration. In fact, our contact, our collaboration with German goes back centuries ago. If you know that Max Muller was a scholar in Sanskrit, he was responsible for translating Upanishad from Sanskrit to German and English, and that's how it opened up the whole, the wisdom of the East, and we'll continue that effort. Thank you so much, and we are eagerly awaiting to hear from Mr. R. Venkatramani, the Attorney General of India, who is a scholar, lawyer, We not and I do not wish to spend on that much more. That we can see from the speech he will be delivering on this with insightful knowledge, not on the law, but also how the states function. With this insightful knowledge, I'm sure we'll get much more enlightened on this very delicate and very important topic of cross-border terrorism and its implication for the rule of law. Thank you. Welcome, Attorney General.
If I'm not too late in the forenoon, let me say good morning to all the honorable guests assembled in Delhi. I speak from faraway Trivandrum, the southern part of this continent. Let me pick up the threads from the speaker who spoke just now about conventions. I think signing conventions is very often a paper, exercise, and whether countries wish to do it or not depends on a large number of political and now global geopolitical considerations. But I think signing conventions happen at a more subtler and important level, namely the human commitment to certain values which go across and do not belong to any particular country today. So I suppose the fact that we are assembled here to talk about rule of law as an international concern is to sign as many conventions as possible mentally and with commitment to promote all the conventions as part of a global commitment to peace and good life for all humanity. And Prashant Kumar wanted me to talk about the cross-border terrorism. It's easy to talk about it in terms of what happened in the past couple of decades, and particularly concerning India. We tend to talk about terrorism in general, and then we also tend to, while talking about that, we bring all those aspects of what is anathema to human peace and human welfare without any distinctions whatsoever across caste, religion, faith, creed, etc. But before I would probably express my thoughts on cross-border terrorism, I think it's important for us, an international body of lawyers who are assembled here in Delhi, and as often as we assemble like this, wherever we are assembling, I think it's important for us to have certain common pledges. The world has closed its doors to Cold War, and it had its own implications for human development across the globe on an equal regard and equal status basis. It's good that we do not allow any more Cold Wars to become part of a global human transaction, understanding, and relationships. Secondly, it's equally important that we do not only have Cold Wars, but we do not have covert or open wars any longer on this planet. Any war, by ones of using instruments of terror, coercion, or such compulsions, I think, are antithetical to human understanding of peace and being fundamentally good to each and every one of us. The third pledge I probably thought would be that we have crossed a long way in understanding rule of law from its early nascent stages and years, mostly coined and dictated either by global institutions such as World Bank or etc. I think it's important for us to plunge a little more deeply into knowing the rule of law as something building relationship between human beings. And if as an individual human being, I do not have faith in law and would not like to abide by law in all its expansive dimension, then there is rule of law is the first casualty at my level. Therefore, it's important for us that to say all legal fraternities and associations will be able to say that we must turn a new chapter understanding rule of law, not merely as one between a state and a citizen, but between all human beings where, to use his expression, equal regard and equal status of all human beings to pursue the best in their dignity and the worth of being human, I think is the ultimate and the goal of human law and the ultimate driving factor of rule of law. If that's how it's going to look at it, I think there is no room in any part of the world, not only in India, in any part of the world, to talk about cross-border terrorism. I think it's important for us to say that whatever a faith or a creed or religion may think about its own importance in delivering personal pursuits of human freedom, etc., it's important for us to say that no faith, no creed, no understanding, no religion will say that you will use violence as the only means of settling human transaction or human disagreement. Having said that, I think let me share a few words on why we need to have a new dimensions understanding of rule of law, and therefore we will certainly talk about not cross-border terrorism as an isolated concern of few countries in the world. Generally, it's being taught. One of the historians of violence says that violence across the world has come down, and one does not know whether it really depicts the correct picture. But historians hold mirrors unto us as if to help us to learn and chart our destiny on this planet, on lessons drawn from the past, whether it's dialectical materialism or any other school. The offer is to assist us in planning our future. Volumes have been written on how violence has been the way of resolving differences or for social, geographical, or religious hegemony. Optimists predict that violence as the means of going around a problem is on the wane. I suppose gatherings like this will certainly put a stamp on that the wane will not revert. We can attribute a significant decline in violence to many factors. The decline and end of colonial occupations, the decline and end of old religious colonization or hegemonical ventures by force, the decline and end of national wars, the emergence of the idea of constitution and representative democracy, the emergence and entrenchment of ideas of rights that can be enforced through impartial tribunals, particularly human rights, civil, political, social, economic, and cultural. Can there be one all-embracing concept, definition, or comprehension of rule of law? Is rule of law an evolution and amalgamation of several political and social ideas, ultimately tuned to limit and tame all arbitrary power, private to public? As we move after post-WTO regime to the emergence of private power on dictating how our minds will work, how our thoughts can be controlled and directed, is an important question, important for rule of law. And is it therefore more closely connected to institutionalize of all social and governance processes, private processes, technology, and all the force of technology, in order that justice, equality before law, and accountability to power, all power we're talking about, are secured by orderly and published, transparent, and accountability procedures and rules. It's going to be a huge challenge as we march into the next machine age where technology is virtually taken over the way we think, the way we act, the way we conduct our transactions. And it's therefore important for us when we talk about cross-border terrorism, where all possible means are pursued to ensure that peace and good means are put on the table. So therefore, why do we need the thin and the thick varieties of rule of law, as we often talked about, and what do they conceal? Political ideologies dressed in new clothes, and I think it's in that context that therefore it's important to talk about giving finally a closure to the Cold War and the new world war that may emerge by using technology and then clothing it with all kinds of new shapes and frames of ideological dialogue. That's why I think cross-border terrorism can take a new shape and then emerge as a wolf in the sheep's clothes. So several statements on the high ground of law and subjection of all people to it and the relevance of rights in securing them have been made in the past. They were made in the context of diverse historical backgrounds and social order. Is it not that they are either partial or incomplete for current universal global reception in view of the neoliberal economic spread and the technological driven globalization, which poses several unprecedented global and local challenges? Or is it that we need to acknowledge multiple concepts of rule of law with common denominators and additional layers of significance? I think it's important for the fraternity of lawyers to ponder on these aspects and to say that we are going to talk about 2030, 2050, sustainable goals of development, etc. But before all that really happens, I think it's important for us to lay our books very clean on what exactly would be the dominating aspects of rule of law and what all forces, private, public, technology, science, and all that controls our mind and thought will be subject to principles of accountability, transparency, and all that. I think that's where cross-border terrorism comes in as far as India is concerned. I don't want to talk about very explosive political issues that have led to recent development because that may have certain partial ways of looking at it. But in order to be impartial and neutral, I still think that no country in the world would like to embrace violence of any sort, notwithstanding the recent wars that are still raging around the globe for no good reason. Therefore, if a legal fraternity can be a great and a sound emerging voice across the globe, and I'm sure New Delhi is a good place to be that emerging and resounding voice against all forms of violence between nations, between peoples, between faiths, between creeds and individuals. And therefore, the Rule of Law Convention being convened here today, with all international legal fraternity, can come here to join hands in a common resolve that we will explore all potentials of rule of law that will ensure that there is no room for any violence on any part of any individual or state entity or private power sectors, etc., in order that we know all that wonderful, valuable riches of our traditions and culture. For over several thousand years, it's said that the only way to live in peace is to understand each other. And cross-border terrorism is a great obstacle to understanding each other. And we have certain concerns, particularly to India, but I think since they are so politically involved, I only wish to say India will be the first country to begin to draft and declare and invite all the legal fraternity assembled here today to say that we will no longer permit or be party to any aspect, direct or indirect, overt or covert forms of violence. I think that will take us the next generation of rule of law. We have all kinds of instruments, political, social, economic, across the world. The UN covenants and conventions have given us rich harvests of thought. But still, if you're not able to really ensure that large millions of people across the globe in different parts of countries and countries have not been able to secure what would like to secure, namely dignity and the worthy of life and a worthy life. How do we therefore ensure that? We have a long way to go, but I'm sure that when we launch on this new understanding of rule of law, where absolute room for violence is issued, I think we will be party to the next generation, post-UN declaration of 1948. And I think that's going to be a great contribution in the Assembly of New Delhi. And I think not because I'm an Indian, but India has many things to offer to the rest of the world. India has offered it in the past. India will continue to offer it in the future. And I was speaking to Prashant some time ago that it is time that there is a New Delhi Convention where we talk about the post-1948 developments and lessons learned from the 1948 UN Declaration and the lessons to be laid on for the future. And this Rule of Law Convention, I'm sure, will be one such New Delhi Convention to be a beginning for eschewing all violence and all peace to be promoted at all costs. And I'm sorry I am not physically present there. I would love to be part of any further deliberation, but I said the New Delhi Convention will be the beginning of a new era and understanding rule of law so that all of us live in wonderful peace and something which probably humanity has not seen and witnessed so far. In a nutshell, we seem to be at a crossroads. Either we hold the rule of law debate is no longer confined to controlling arbitrary power through supremacy of law, repeating importance of equality and cataloging rights, or we stand by the emerging demand that rule of law must get into fundamental questions of political processes, social process, economic process through which rights, duties, expectations and needs are debated and administered. Constitutions are abided by. Discretions and public policy choices are open to correction, and that no dispensations of any sort are made under cover of assumed wisdom of any system of economic or political ordering. We will not be merely discussing impartial courts, fair trials, known laws enforced through known published procedures, and We are now called upon to resolving conflicts and antinomies generated by capitalism, freedom of property and contract, access to and control of community resources on the one hand, in the name of innovation that will eventually meet all human needs, and social control of all human activities on the other through regulation and intense supervision in the name of social justice or socialistic legality. Strangely, some countries have chosen hybrid models of organized freedom and social controls, which have become laboratories for pundits of economic and social studies. Of course, I think in this context, the Rule of Law Convention assumes importance. We need to have a code for a new rule of law, and who else can frame this code except the fraternity of lawyers gathered from all across the globe. I thank you for your attention, and I'm sure we'll be on a long but a quick and comfortable journey on understanding and unraveling the new dimension of the rule of law. Thank you so much.
Attorney General, for your insightful exposition on this very delicate issue of balancing the need to protect our values against terrorists who do not believe in such without compromising with the basic legal principles. Thank you, Learned Attorney General, for that. Next, we come to the last of the speech by Prashant Kumar, the key principles of the international rule of law and economic justice and application in international economic governance. It is very important for the reason that as far as the national domestic issues are concerned, we understand the rule of law guarantees a level playing field, enforceable contracts, property rights, and constraints on arbitrary power, all ingredients for economic growth and fairness. How do we translate these principles and values in the international plane is something which needs to be also will be explained by a learned speaker, the president of the association. Thank you.
Thank you, Justice Koteshwar Singh. Mine is the last speech between you and lunch. So I'll try to be brief, but then there are certain concepts I wish to place before you. Friends, when we started sending invites to all of you to attend this convention, there are certain developments in the world which had not yet taken place. We conceived this convention last year and sent you save the date around July and August. The world changed in many ways after November and in the beginning of this new year. Earlier, we used to use a term that we are at crossroads. I will use a slightly different term without elaborating it much, because all of you understand. The world is today at a T-junction. There is a dead end. You go to right or you go to left. But ultimately, if we don't uphold the core values of humanism and fairness, whether it is right or left, it is again a dead end. And one more fundamental thing I wish to point out. When we talk about rule of law, we cannot disassociate it completely from politics or geopolitics. And that is where my strong feeling is that if in global geopolitics, member states, big nations, small nations are agreeing to negotiations which the people can see, uphold none of the basic values and conventions, are purely transactional. So it is not merely a question of international rule of law or international economic governance, it becomes a fundamental channel to the faith and belief in the domestic rule of law. Because when you say the states and governments agreeing to negotiations which may not fully protect, they may not agree in normal times, it undermines faith and trust in the rule of law, even domestically. That's why we stand at a very critical point in history, but we also know that this may be a passing moment in the long tide of history. That is why this convention wishes to concentrate not on what is going on right now, but how these structures should be there for the long term to sustain global economic governance. I will not go into the factors of the rule of law. Many erudite speakers have explained them. But when we try to incorporate them into global economic governance, we look at predictability, which means clear, stable, and consistent rules are applied in economic policies and in international economic frameworks. And there is an element of equality, which means fair treatment of all states and actors, regardless of their economic power. Then comes accountability, because ultimately, whatever we can perceive today as constituting international economic governance, that is run through international institutions, which are primarily the outcome of a post-Second World War system, which was erected to maintain a status quo to prevent wars. But was it created for the times of today, when even in United Nations we have gone forward with the concepts of sustainable development goals? We have gone forward with the conception of ESG. We are now working on these progressive global instruments, which, in my opinion, are based on the core values and principles of rule of law itself, because they try to promote sustainability, they try to promote justice, they try to provide fairness in how things are balanced between the rich and the poor, how in climate justice, climate finance, and even economic bailout packages, how the instruments are structured to be fair and equitable. So that is why this discussion on the rule of law being the basis of global economic instruments is something which should try to understand in a holistic and wholesome context. When I talk about the world on T-junction, it is this year's development. But just look at it. World Trade Organization, which was created to bring fairness in international trade through instruments like most favored nation treatment, non-discrimination, which are all core principles of the rule of law, is dysfunctional because there is a complete paralysis in its dispute settlement system from 2019. So it was not something brought in by COVID, it was before COVID. It is a paralysis which is enforced, and it is a big body blow to the kind of globalized world economic relationships we were imagining and we got used to. Now, the other instruments, because the world, the institutions have been created to support the weak, support those who are under crisis. And those institutions are IMF and World Bank. We have a topic on debt restructuring, sovereign debt restructuring here. But we must, as legal scholars, look into the aspects that how these organizations have performed, how they have lived up to the principles of rule of law in terms of consistency, in terms of fairness, in applying conditionalities, in making prescriptions. Then again, international investment law, India has cancelled a lot of bilateral investment treaties because how the rights of communities, environmental concerns and other overriding concerns are to be looked at, while you also look at the enforceable rights for investors. And here I have a personal opinion, all may not agree. According to me, as a very basic economic concept, the profit is in direct proportion to risk an entrepreneur takes. When investors go to developing countries and emerging markets, they go there, they make their investments, private enterprises, not for granting any development assistance, but to make profit. And profit also at a scale which is not available in their home jurisdictions, where you have returns 2%, 5%, 7% at the most, being very, very healthy. But you go to developing countries looking for returns over 20%. So you are, by this huge margin, by this huge prospect of economic returns and profit, you are taking a calculated risk. But you also want a double cover. I should take a risk, but my risk should be protected by legal instruments which interfere, according to me, in the normal setting of economic relations. So that's why one of the aspects I want to pose before this assembly is to think about investment protection. One, in the grading, where it is most extreme, that due to a regulatory change, entire investment is appropriated, or where due to various sovereign actions which are necessary for protecting the domestic interest of the communities who own the natural resources, who are traditional owners of such natural resources, which now the investment wants to develop and exploit commercially. So if certain thing is done through interference of courts, through interference of public outcry, in terms of giving some share to such communities while these profits are made. So whether that should result in a breach of an investment protection treaty, and the state which is inviting investment so that the economic standards can be improved, instead suffers a huge damage in terms of international awards. So this is one basic economic principle and impulse which we have to balance. So I think this is an aspect of international economic governance. Just to give you a little idea, I am talking about IMF conditionalities and the rule of law. If you look at various phases of IMF's working, you will find that IMF conditionalities vary across time and regions. and that undermines the core principle of consistency. Developing countries face stricter austerity measures. We can look at Asian currency crisis of 1997 and in Argentina in 2001, and we can compare it with Eurozone crisis in Greece of 2010 and what has happened recently in Ghana and Zambia. Indonesia, in 1997, 16 banks were closed abruptly on the basis of recommendations and as part of the bailout package. Subsidy cuts. It led to riots and deep social crisis, which undermined the rule of law in Indonesia while offering a hand of help. In Argentina, the rigid austerity measures led to social unrest and to a further default because there were no conditions existing to support those recommendations. The same thing has nearly happened in Ghana and Zambia. So that is why we want to discuss here that how these recommendations and these packages by the international organizations which govern the international economic frameworks take shape. And as members of legal community, we must be able to make suggestions and concept papers to ensure that these frameworks are wholesome. In fact, one of the greatest living philosophers, Noam Chomsky, has said, these institutions, IMF, World Bank, WTO, are instruments of power, not of democracy. Their decision making is secretive, their policy is unaccountable, and their impact devastating on populations with no voice in their design. And that is where we say that the core principles of international economic governance must be informed, must be posited in these policies, that is predictability, equality, accountability, transparency, and inclusiveness. Friends, we are short of time, and I want to just make a reference to two of the Indian economists who have given their ideas on international economic governance. One is Professor Jagdish Bhagwati. He says globalization's critics have a point when they argue that the system has often been rigged against the poor, but the solution is to reform it, not to destroy it. And Professor Amartya Sen, the Nobel laureate, has said globalization is not intrinsically good or bad. What matters is how it is governed and whether the benefits are shared and the burdens justly distributed. So I think if we are able to identify these principles and we are able to act as legal profession, as advisors, to push these, as bar associations to push these ideas, we will be contributing a lot, because otherwise, as again Noam Chomsky has said, that because lawyers must play a role as well, because IMF economists are like medieval doctors. If the patient dies, they say, well, we applied the leeches correctly, the medicine was right, the patient just failed us. Global population, especially in global south, is not a patient we should fail. Thank you very much.
Thank you so much. Mr. Prashant Kumar, within this, in spite of time constraints, we have been able to give very, very concrete suggestions as to how this rule of law can play out in the international level. In fact, a rule of law is not static, is dynamic, is constantly evolving, and we can say certainly that an effective collaboration amongst nations believing in a rule of law will be a facet of rule of law itself. Thank you very much for giving your attention to all these wonderful speakers who have deliberated on various aspects of the rule of law. Thank you. Thank you very much.
We will now assemble for the next session at 2:15. Please have your lunch in between. It is served in the basement to this hall. Thank you.